definitely going to be running the chat box. Jakki's got incredible story of her journey working as an IMCA and a broader advocate. And I think it's going to stimulate lots and lots of discussions and kind of hopefully challenge us to think what we're doing with advocacy, what the point of advocacy actually is. So please do put your comments in the chat box. And Jakki's also happy to take questions at the end. So we'll do a Q&A session to kind of for as long as time permits. So if I can introduce Jakki, who has been working in advocacy for how long, Jakki? Is it 15 years?
Longer.
This is where you feel a bit older than a lifetime. And she's managed advocacy, so she's definitely walked the walk. She was around right at the beginning of IMCA, and she describes herself kind of pushing at the edges of the Mental Capacity Act, which is a great phrase. But her experience is broader than advocacy. She's also co-founded COPPA, which, forgive me, Jakki, I know it's a Court of Protection
Practitioners Association,
thank you. And she chairs that, which obviously isn't for advocates, it's for everyone involved in Court of Protection. And really significantly, Jakki has been involved in some monumental cases that have gone to the Court of Protection and helped to create case law that we've got. And I think she's going to talk about some of these today, which is really exciting. So welcome, Jakki. I'll hand over to you.
Okay, thank you. Bear with me whilst I do the technical stuff.
There you go, looking good.
Okay. Right, bear with me.
Yeah, no, looking good. So we can see the slides. Yeah, perfect.
Okay. So I'm going to come in and out of the screen sharing because some of what I'm doing today is talking from my book and just kind of talking. And even though I can't really see anyone, if I only see the screen, it feels like I'm talking to no one. So bear with me when I stop and start. So I'm going to be talking about my book, which is called Life, Death and the Journeys in Between, Stories of an Advocate. And I spent kind of the last couple of years or so writing this book, and then it was really ready to be published at the start of an international pandemic where everyone's watching Life, Death and the Journeys in Between. So it was quite an anxiety-provoking moment, actually, to publish it in such an odd time. But anyway, here I am. So in terms of today, I mean, this is partly what the book is, what's on the screen, the session today. And so I'm going to be reflecting on the role of advocacy over the last 2 decades, how it's changed and where we're at now, or more so where we're at now. The book kind of focuses on some of the past. And me wondering whether we're telling people's stories to enable them to have change in their lives, or whether we've become too focused on a criteria that leaves many voiceless. And I am of the view that we are leaving many people voiceless. And then also what it means for each of us to be alive and live, and ensuring that our voice is heard. So just to offer some context, and I don't know how many people are listening, stroke watching, that have read my book, that know anything about me. So this is my book, and I'm just going to read the synopsis from the back, just to offer some context really as to what I'm actually talking about, because I am going to read through some of people's stories that I talk about, but I'm not going to start at the beginning to end of each of them. So if you don't know anything about the book or my work, hopefully this will offer some context. Imagine going to work one day, getting knocked off your motorbike en route and never leaving hospital, having sustained a traumatic brain injury. That's what happened to Paul Briggs, a Merseyside police officer who was left in a minimally conscious state. Richard was knocked off his pushbike and never regained consciousness. Mrs. N had multiple sclerosis and was unable to talk, move her body, or express herself in any way in the 8 years that she lived in a nursing home. Jodie accidentally overdosed on medication and was placed in a nursing home, remaining in a permanent vegetative state. June has to go home from hospital before she became unconscious. She never got to go. Their stories are interwoven with mine because I had the privilege to be part of all of their lives and deaths. In 2003, I became a mental health advocate, determined and passionate about being a voice in and for people's lives and making sure the most vulnerable in society, people with dementia, brain injuries, mental illness, and learning disabilities were heard. Little did I know then that I'd end up advocating for death, for the end of people's lives, and arguing that being alive really wasn't what everyone wanted. Life, Death, and the Journeys in Between tells the stories behind the court cases, sharing the unsaid in what at times were desperately unhappy and grief-stricken times, but also times that changed the law and the rights of those without a voice. A book aimed at those who work in this field, those affected by traumatic brain injuries, their loved ones, advocates, and anyone interested in the human story that is simply life, death, and the journeys in between. And it's also about the author, what it's like as an advocate, as a professional in these people's lives that is ultimately advocating for them to come to an end. It's about my own relationship with death and trauma and the system that surrounds both. So all of those people that I'm talking about in the book all come under the umbrella of being in a prolonged disorder of consciousness. So some people were in a permanent vegetative state and others were in a minimally conscious state. And as a kind of lay person, and what went discussed in the court immensely really until the law eventually changed, is that the diagnosis of each person, from the observational, say, family members, for example, there was very little difference. And they would say that diagnosis doesn't make a difference to the life that this person's living, to the treatment that they'd receive, to their life from here on in. It doesn't make a difference. It's so minute of a difference in terms of consciousness. But to really, to really know or to find out more, I suppose, about disorders of consciousness, whether that comes into your life for whatever reason, the Royal College of Physicians guidelines is where all of the information is. And so I was part of the Royal Guidelines, the Royal College of Physicians guidelines group to revise the existing guidelines in, I think, around 2011. For a couple of years, and then they were revised again and I think published the end of last year, and I was invited to be part of that revision group as well. And the guidelines came about, so they did exist anyway, but they came about in terms of the revision because there was the first case of someone in a minimally conscious state to go to the Court of Protection where her family were asking for treatment to be withdrawn, and it wasn't authorised, and it created quite a lot of conversation and discussion and views as to whether that was the right decision. And so the guidelines were then revised and then revised again once changes in the law started occurring in this area. And just to say, in terms of that difference with regards to diagnosis, M in that first case was initially diagnosed as being in a permanent vegetative state, and it was only when the levels of assessments that occurred from various neuro rehab experts that diagnosis was changed to minimally conscious. But what her family said is it doesn't make any difference. It doesn't change anything. It doesn't change her presentation. It doesn't change her life. It doesn't change her ability to interact. And as I say, the law did recognise that. Just in terms of kind of real life people, by which I mean, if this still feels maybe a bit unfamiliar, the real life examples of people that you've probably heard about or followed or read about. Michael Schumacher, who sustained his traumatic brain injury when he was skiing and was still talking to the paramedics based on media reports after the accident and on his way to hospital. he is likely, it seems, in a minimally conscious state based on the small snippets of information that are released by his family, and is probably going to remain in that state, given the length of time that he's been in this situation, kind of regardless of what some of the media recovery stories sometimes state. Jules Bianchi, who was also a Formula One driver, and his accident was aired. He was driving, he was racing, and it seems that he was in a permanent vegetative state when he died, based on what his father said to the media. And then Tony Bland, who was the 96th victim of the Hillsborough disaster. And in terms of this area of law and medical treatment and consciousness, I mean, he was the first person, I guess, to come into people's vocabulary in that field, but I mean publicly. So in terms of what made me write the book, I mean, it was to tell the story, really. People were talking about the cases in various places, social media, conferences, and I wanted to tell the story of P, the real kind of version, the family experience, and my experience. I wanted to talk about advocacy in the sense of how I became the person's advocate and how that had led me to believe that advocacy wasn't working as it should be. And not to subliminally get the title of the book in your brains, but genuinely to talk about life, death, and the journeys in between. What does living mean? What does being alive mean? The Court of Protection talks a lot about sanctity of life, but what does that mean on an individual level? And how do we tell stories of what being alive means? Someone may not have ever expressed a view on a particular circumstance and a particular treatment. So we can't know what they'd want in this particular situation, but that doesn't mean that we can't find out about what life was for them. And how we're seen. Do you know how you're seen? What others understand about you? And then finally, most importantly, I wanted to talk about P, and really the way P is treated, and what that says about us as a society, and how we can use that within our advocacy. So I'm going to be reading some extracts from the book, just to expand on some of, well, not expand on some of my thoughts. These were my thoughts, and I'm sharing them. And then hopefully there will be good enough time to have some discussion at the end, and hopefully me talking won't be too long either, in terms of concentration levels.
I think people are loving listening to you, Jakki, with the chat.
So I'll just go back a second. So I'm going to read some parts from the book here. So here I'm talking about the official solicitor, and I've talked about the OS throughout the book and different people's court cases, and really kind of come into well, I needed to express a view. So, sorry, I just think I'm just going back to sharing the screen a second. Sorry. Right, there we go. So I'll come to that bit in a second. So I was just missing a bit out. So in terms of telling the story, so the example that I'm going to talk about with the official solicitor, that was part of what I wanted to share. Social media, everyone has an opinion, and especially during these court cases, everyone had a view, and it was difficult not to respond to that, especially seeing views that felt in direct contrast to what my own experience was. And it was about being able to talk about what the judgment reads like versus the lived experience. I mean, the judgment can never, of course, convey exactly what it's like. And, you know, people like Mark Neary, if you see the judgment in Stephen Neary, you can read through it and be shocked, but then still not necessarily know what that meant in reality. And I think that's something that Mark's done an awful lot of. And just as another example, I remember during the Paul Briggs case, one of us that was present within the court, I can't remember who, but shared I think it was a Times headline, and it referred to Lindsay, Paul's wife, having to fight in the court of protection, and a barrister taking real issue with that word fight, the media using the word fight to describe the court of protection. And she was right that the court of protection isn't meant to be a place where fights occur. But I wanted to say, but it is. This whole journey to get here has been a fight. It's been incredibly difficult, a fight with the legal aid system, the health system. It was a fight, but, you know, it wasn't appropriate to share that at the time. And then there was also family wanting to have their story told, but not by them. So they didn't want to say go to a newspaper and then the local community suddenly have a story about them. That wasn't what they wanted. But they wanted their experience to be shared. So that wasn't forgotten, and that what might look like, what appears on a judgment can seem straightforward because it's just focused on the decision. The process to get there was not. And I also wanted to talk about my own experience, my journey, the impact of all the cases, kind of advocating for death, essentially, and experiencing what that meant for other people was quite the experience. And then to advocate for P and advocacy, really. So I mean, I'd written guidance about IMCAs and IMHAs and non-instructed advocacy and mental capacity and assessing capacity. But that's about, so here's what it says in the law and this is what it looks like. I wanted to do beyond that, really. This is the part that I'm going back to the official solicitor. So I am referring to Paul Briggs here, but it was my general sense as to observing the litigation friend who was the official solicitor, and a litigation friend is meant to at least represent someone's views represent them, at least that be part of it. So for me, in terms of the official solicitor, I'd reached a point of, is it just me, or is there something that isn't right with this representation? Alistair Pitt-Blado has since passed away and cannot obviously make comment on this. And I mention Alistair Pitt-Blado specifically because he was the official solicitor for the duration of all of the cases that are referred to in the book. And Sarah Castle is now the official solicitor. But it was reasonable to say that it was no secret that he, as the official solicitor, had his own values with respect to sanctity of life. Indeed, the OS as an office are very clear this is a core action of theirs, to promote the sanctity of life. And it's the start of all of these types of cases regardless, and that's crucial, it's not criticism. Specifically what I mean, though, on that is it was clear for anyone to witness that where a serious medical treatment case was considering the notion that P would not want treatment, such as someone like Paul, and that there's evidence and there's past statements, the OS would argue against this, as opposed to making that the initial representation. I distinctly recall being asked by a journalist when the decision had been made for treatment to be withdrawn, and there was a query of whether the official solicitor might appeal that. And the journalist saying to me, but the evidence is that Paul would not want treatment. Why would the official solicitor appeal? Don't they represent him? And my answer was, well, yes, that's true. That is what's meant to happen. But it was striking that for someone that wasn't kind of seeing court of protection and serious medical treatment all the time, could see that quite distinctly, that this didn't seem to be a representative role. There's a difference between the best interest view being not what the person would want, but that should at least be expressed, that the person's views. And then I'll just briefly share this again, and this is also from the Paul Briggs case. But I wanted to share this because this type of minute stuff, it was actually huge. And that stuff isn't going to be in the judgment. People aren't going to hear it or read about this. But one of the reasons that I got involved in the Paul Briggs case in the first place was because Lindsay, his wife, had been saying to the consultant that was in charge initially, she didn't think he'd want antibiotics. She didn't think he'd want active treatment. And there was a lot of reasons and evidence to support this. That doctor kept on saying, no, it's illegal to not prescribe antibiotics. And her boss at the time was a cardiologist. So she put it to the cardiologist, who said, that's not true. But this kept on being told. So then she actually asked me to become involved to be Paul's advocate. And I'm referring here to Paul is in one hospital and has to go to another hospital, the appropriate neurospecialist rehab hospital. But there was already quite a bit of evidence at this stage, including letters that had been written by his family, that he wouldn't want active treatment. And I wasn't asking for any decisions to be made in this meeting. This was a straightforward, is it in his best interest to go to the other hospital? I was just saying, can this be handed over? Because he is going somewhere for active treatment, and his wishes need to be known. I refer to the ceiling of care, treatment, as per the guidelines, i.e. such treatment decisions of whether antibiotics are provided, whether a DNA CPR is in place, all decisions about Paul were best interest ones. I wasn't being controversial, I was simply pointing out the law. The consultant believed I was wrong and he was right. He told me it was the law to prescribe antibiotics to Paul, that it was against the law not to prescribe, and that he'd go to jail if he didn't. He told me it was General Medical Council guidelines that dictated this. And he said a decision about not prescribing antibiotics could only be made after 18 months of prescribing them. And only the Court of Protection could authorise that. I said to Mr. H that the guidelines in this instance that needed to be followed were the Royal College of Physicians, and they very clearly state that ceiling of care is a discussion that must occur. There was absolutely no rule that stated this had to go to the Court of Protection. This is just about antibiotics. This alternative fact situation kept going. Soon after the above meeting, going to Walton Hospital, and I was recounting this story to the rehab nurse, now liaising with family and me. In my naive state, I thought she'd know about the Mental Capacity Act. Their patient group, after all, has a brain injury. And that's not to say everyone with a brain injury has mental capacity issues, but you'd expect to know something about the MCA. It seemed obvious they would know everything about it. I was wrong. And I would just say at this point that the neuro rehab consultant actually said in court that she'd never had any training in the Mental Capacity Act. So the nurse replied, well, he's right, it would need to go to court. I actually began thinking of Mr. Memo on this. If everyone was so sure that a decision about not prescribing antibiotics could only be made by a High Court judge, maybe they were right and it was me that was wrong. She left the room briefly and I quickly got out my phone and searched Practice Direction 9E, serious medical treatment, which was then one of the rules for the Court of Protection in terms of what serious medical treatments had to go to the court. I actually did this. Never mind, I'd just spent the last year on a working group discussing said practice direction. I knew what it said. But now a nurse and a doctor in two different hospitals were utterly convinced that I was wrong and they were right. Turned out the practice direction was how I'd remembered it. So, as I say, I also wanted to talk about advocacy. So the first PDoc case that I talk about in the book came from the fact that I was on the guidelines group. And it was just, there was someone on the group who was a solicitor and his colleague was a property and affairs deputy for someone in a disorder of consciousness. They had appointed a case manager, a brain injury case manager who suggested an advocate. And the person's brother was really on board with this. And I think that that's important for me to say that family can be very supportive about advocacy and want it. He often worked away, so that was part of the reason, but he also wanted someone to know about his brother, someone that was independent, that didn't have a decision-making role as such. And he would also say, just because I'm not in that bed doesn't mean that I will survive longer than he will. What if I'm not around? I want someone to be his advocate. And I've been an advocate I've been instructed by power of attorneys. So the person's already asked someone to make decisions. And then that attorney says, actually, I wouldn't mind someone independent helping me with this and becoming involved. So it's not all about my own personal wishes. So again, that's important to consider, I think, when we're looking at mental capacity advocacy. In every case that I was part of, an IMCA would not have been appointed because the person had family and friends. And in all the cases that I talk about that go to court in the book, there wouldn't have been an IMCA. And I'm not suggesting that I was somehow the saviour in this, and that without me, the law wouldn't have changed and no one's rights would be adhered to. I'm not suggesting that. But I am wondering what would have happened had I not been involved, but also, why should that have to happen? If someone needs an advocate, if there's known to be a benefit, if someone's voice needs to be heard, why are we stopping that? I've come across people, and by people I mean Pete, who've had an advocate, an IMCA instructed, and they'd argue their way out of that it wasn't necessary because there were family involved. And then I become involved. And I just wonder whether we're ignoring family experience. We're placing the role of advocacy on them in the same way the legislation has done that. And I wonder why. You know, going back to the beginning, the Making Decisions Alliance didn't campaign for people with family not to have advocacy. It was across the board. This is a resource-led issue. And I'm not suggesting that that you can suddenly change the criteria, because you have to adhere to that and you have to understand the funding that's in place for that. But I'm wondering if as a sector we're enabling P's voice to be silenced. So just to kind of expand on that a little bit, because I talk about it in the book. There's also an assumption in this appropriate to consult criteria that family can see and think clearly through a traumatic event, that they're not dealing with a completely new life they found themselves in and do not have their own emotions going on. My point is that family members are family members. Professional advocates are people paid to do a very specific job, so why do we conflate the two? There's also a value-driven assumption or expectation placed on families within this, that they must act in a certain way or do certain things to be taken seriously. We know this is true. We've seen it in Mark Neary's descriptions of his and Stephen's story. We see it in Dr. Sarah Ryan's story when she talks about Connor and how he died, her son. We've seen it in Paula McGowan's story when she talks about her son, Oliver, and him dying and her not being listened to. We see this, and yet as a sector, we're kind of disengaged from it. If a family is too assertive, confident or knowledgeable, there is a risk they're viewed as challenging and the weight of what they say becomes diminished. If they disagree with decision-making or communication or the way communication is going, there must be something wrong with their expectations and therefore risk being alienated from wider discussions. Family are often placed in a mould of having to be whatever another's version of perfect is in this particular situation. If they don't fit it, they can become marginalised or demonised. Equally, the family that goes along with everything, they don't challenge, they don't ask questions, they agree with everything. Maybe because their own experience of values and life story tells them the person in charge can solve this and work out what's best, what the outcome should be. This is no better than the former because it also stops an open dialogue and an open, transparent conversation about here we are and where we're going. The nature of statutory advocacy has brought us to a default position that advocates are viewed as substitute family members. This works both ways in that sometimes family can hear at the mention of an advocate that they're not being the person's advocate, the role is being questioned. They know the person best and that's being queried. But I hope no advocate would ever believe they know or could know a person more than those that actually do. Our role is not to suggest otherwise, but to be an independent person in decision making. We come without emotional attachment to the individual. We work with facts, information, knowledge of the law, decision-making processes and expectations, the skills of ensuring a person's voice is heard, a holistic and person-centred approach. In considering what advocacy is about, i.e. the individual at the heart of decision-making, The very real issue that if you're the person who the decision is about and you're a family member, you're reliant on that hope I've referred to, that everyone knows what to do, all information is correct, and the decision made will be in your best interests. And I just very briefly want to read a couple of paragraphs to kind of explain this, to the way they want family being seen in a particular lens and how that could change everything, even if that lens is not remotely based in reality. So this is about the case of June, who was a woman. She had 2 adult children. And she was not someone that took an interest in her health. She had various health problems and she did not adhere to clinical advice. That wasn't who she was. But the only thing that she would kind of pay attention to was her eye. She had an eye condition and there was a risk she would lose her eyesight, and she never wanted that. So she had headaches one day and she worried that it was her eyesight. She took herself to the eye hospital in Manchester and then was admitted to hospital. When her 2 daughters get there, although she's confused, she's saying that she doesn't want to go. She doesn't do hospitals. She doesn't want to be in this environment. She later became unconscious that day and went for emergency surgery and never regained consciousness. Soon after that happening, it was clear what her sort of consciousness levels were going to be. Both her daughters said she wouldn't want this, she wouldn't want treatment, and there's lots of evidence. And at that point, they were shut down. Any discussion was shut down, and that impacted on the way they were then seen. So this is from the court case, and this is a nurse giving evidence. It became clear from how this particular nurse began her evidence that she held judgment against the family, and it wasn't always clear if this was based on facts or what became her version of events. And we all do that to some degree. We fill in the gaps we have with our own values, judgments, hypotheses, at times without necessarily knowing it. I saw this because the nurse began her evidence stating that in all her years of practice, which is always a significant statement to say, she'd never seen a patient less visited. So much laid in value judgment in just a few words. It was clear she was conveying they don't visit, they don't know this part of her, I'm not sure how much they do care. So much to unpick as well within that. What's the norm for number of visitations? Do people only get visits if their family love them? Or is it possible not to visit someone because it's distressing, it's geographically difficult, and still love them? The judge asked the nurse if he was aware that family had been told to take items home that they'd brought in. She said no. That they'd brought in a radio that went missing, she wasn't sure. I can't speak for him, but my memory and no notes of this exchange was she'd implied something quite significant, her tone, her disdain actually. It was evident. I remember talking to both Megan and Sarah about it and how astonished they were at a member of staff seeming to see them in such a certain shadow. Because family did visit regularly, they'd brought items in that had been suggested to enhance June's recovery, but then later been told to take them home and items had gone missing. We were also talking about 2 daughters who both had children at school and full-time jobs. One of them was living in another part of the country, a significant distance away. Context is key. Megan later disclosed within court, after the nurse's evidence, that since March she'd been unable to visit. In fact, she'd been unable to leave the house due to depression and anxiety. And before I go on to the next slide, so this is just a brief synopsis of Jodie Simpson. I can't remember exactly how old Jodie was, but we're around about the same age. She might have been a little bit older than me. So in this time, she was probably around late 20s, I think. In August 2012, Jodie took an overdose of diabetic medication, not hers, and sustained a hypoxic brain injury. Her brother Michael found her unconscious at her house and she was admitted to hospital. Jodie had a history of living with depression as well as being someone that liked to have a good time. She liked parties, she liked going out, things many of us do regardless of age or sensibility. It appears highly likely, based on what Jodie's family know of her, how they've described who she was before the overdose, her state of mind just before this, the circumstances, and concluded within the coroner's verdict that this was a simple but tragic accident. Jodie could not have known the impact of the medication, the way she might be found by a brother who adored her, and she him. And there'd be no reason to ever believe she would intentionally leave her 2 children. It was a tragic accident and seemingly a spontaneous act of someone that both lived with a mental illness and who at times managed this through getting high in whatever form that meant. So that's just a part of Jodie's story. She had lots of stories before and she had lots of stories afterwards as well, that she wouldn't have been aware of, and that shouldn't have happened. But we're all made up of stories. Decision making happens based on these. When we're making decisions about our own healthcare or our own circumstances, it's past stories and current stories that enable that make that happen. We tell them on social media and we tell different stories, but they come from all who we are. On Instagram, for example, I just share nice photos that make me smile, and it's a lovely, peaceful place to be. On Twitter, I'm more angry at life. My point being that there's kind of different stories to be told, but they all sort of lead back to the one person. We have different stories with our close friends. Our stories are shown within our family, our environment, our home, social life, the way we enact out our values. And I'm not saying that all those stories are good. There can be loads and loads of bad stories that lead to decision making. But I think as well that we're different in different environments with different people. And one thing that really stood out in a lot of this advocacy work is being able to talk to so many people. So being able to talk to someone's spouse, that child that lived with them versus the child that lived in another country, the business partner, the lifelong friend, the colleague, the supervisor, all of those people would come with stories. And some of them would just be a story, so this is what it says about them kind of thing. Others would be a mix of how their values came out and how they lived their life. But so many stories that enabled me to, with each person, feel that I'd really kind of grasped what had been important to them before this current situation. We ensure that P's voice is heard when we try to find out their story and then tell that within the decision. Because we have statutory advocacy and a criteria-based advocacy, it's very easy to stick with this is the decision that needs to be made. And if it's a decision about life-sustaining treatment, as I said earlier, we may not be able to find out the person's views on that, but we can find out what life was to them. And then finally, this is my last slide and my last bit of talking. But I said to talk about P, how family are treated, how the person's advocate is treated directly comes from a place of thinking how P should be treated. And that doesn't mean that it's malicious. That doesn't mean that it's unkind. But that's what happens. And as a sector, I wonder if we're recognising this in the way that we need to. Are we being the true voice of P and engaging that there are people in the advocacy sector that have a lot of influence in terms of contracts, in terms of the volume of people that they're speaking to. And I feel we need to use that to advocate for P and to highlight what P's experience might be, even if they're not aware of that. I mean, that's kind of even worse. So if it's a fight, do you know what that's about? And can you do something with that? Is it about a whole culture, as it was with Paul Briggs, as it was with June? That was a culture in a hospital that was going on. So I just... my final bits that I'm just going to read out. Again, this is about Paul Briggs. This was the last best interest meeting that we had before the application was made for court. And I use the term best interest very loosely. There was never a best interest meeting. There were basically clinical handovers that I sat in on. There was never an opportunity to talk about Paul. There was never an opportunity to talk about any of this. It was everything was always shut down, and it was one of the kind of biggest gaslighting experience I've had of my life, really. So the meeting, we were told it would be chaired by the medical director. It wasn't. The trust legal would attend. They didn't. Lindsay, his wife, so traumatised by how dismissing and gaslighting this was, to be honest, said she couldn't attend. She asked for a statement to be read out the meeting. She was told it would be. It wasn't. Said there'd be time to discuss Paul's past wishes. Didn't happen. All sorts of things promised. A decision about the court, that an application would be made, didn't happen. So here I'm just talking about an element of that meeting. There were more than 10 health professionals in that room, most of them doctors. I recall wondering what power I had, or rather what power did all of these highly qualified professionals think I had that warranted this level of attendance. It felt extraordinary. I could tell them Paul's wishes, others, advocate, talk about and reiterate different case law, as I had been doing all this time, state what the Act says, but I could never make an NHS trust do anything with that. And yet there I was, a room full of highly skilled professionals needing to tell me everything that I was saying was incorrect. The main person to tell me I was wrong was the ward manager from the unit that Paul had been on. And he began by explaining that he'd been in the same army regiment as Paul, but a different year apart. They didn't know each other. Paul had been the youngest serving soldier to go to the Gulf War. He was 16 years old. And he eventually left the army and joined the police. But this ward manager had also been in the army. He said he understood soldiers. As he stated, this report, meaning mine, whilst he pushed it across the table dismissively, as if it was meaningless and fantasy. I remember physically shaking in that meeting, anxiety mixed in with anger, or maybe it was her, a kind of shock at this dismissive shove of my report. This was how little I was respected, yet they still needed all those professionals to explain they were right and I was wrong. But at the core of this, my report, the work I'd done, all of that information came from those that knew Paul, real life explanations, stories, emotion, all of that laid out, and none of it mattered. Maybe hurt is the wrong word as I reflect. Maybe it was more of a sickening feeling when you realise what you think about the world isn't remotely as your own values feel it simply has to be. It went on to tell me that he knew soldiers, how those in the military thought and functioned. He told me soldiers were fighters, that many went to war zones, and look at them now running marathons. But Paul isn't going to be running a marathon. I mean, we heard in the court case that Paul could only move his index finger up and down, an occasional movement of his toes. That was as much mobility as he had. And we were told that he would probably lose the ability to move his index finger because it was so exhausting. He conveyed a sort of shared connection based on their similar history of life in the army. He felt he understood who Paul was, his personality. We had good chats. Paul hadn't verbally communicated for a year. That Paul appreciated someone being firm with him. That he responded to him. He described them sharing the same sense of humour, giving an example of he spoke to him, and the response from Paul, maybe an occasional smile. No one else saw Paul smile, no one. He essentially said my report was wrong, that where I'd referred to Paul being in the army, I hadn't noted a soldier's mentality. I gently pointed out I hadn't made this up. These were stories told to me by those who knew Paul. I also highlighted that Paul was no longer in the army. He was a police officer, and much of the information I gathered came from immediate colleagues, those who knew him now. I highlighted that he hadn't come back from war. He'd been on a motorbike in Merseyside and had been hit by a car. Whoever he was talking about was not Paul. I don't suggest to have known Paul, but I can categorically state that Paul was physically unable to smile or have a conversation. And I just say here that I don't judge any health or social care professional for caring or for wanting someone to not die or for having real difficulties with being part of a decision about someone dying. I don't judge any of that. What I will always judge, however, is when any professional or individual dismisses another's voice, that when that individual can no longer express it. I do not claim to be an expert of P, whoever P may be, but I have taken time to get to know them in the best way I can. By speaking to those who did, their colleagues, their partner, their mum or dad, their siblings, friends, even someone's local pub landlord many years ago, the neighbour. This is our connection to the world when we can't express it ourselves. Our past, the way we lived our life, our passions, interests, political views, social media use, many facets of our lives. The person being treated by healthcare professionals is just one element of their life, just one. This is their current story, right here, right now, a hospital patient, but it is not their only story. And a judge when others who have never attempted to truly try to know P imply they now know everything about them. That what their family says isn't true, what their friends say isn't true, unless any of these people agree with a personal view of said professional, then that's when they can be believed. All I ask is to be open to trying to find out about the person, their life, their story. You may even find out you wouldn't have liked them if you'd met them before their brain injury. But ask about them. Do not project your own view on who they are based on your personal view or value of medical treatment. This is what advocacy tries to do. Always ask and get others to see an individual. And that is the end of my talk. So those are just to remind you again of the book if you want to access it. So thank you.
Oh, loads of love in the chat, Jakki. Okay, so we're gonna go for questions. I can't see too many actual kind of questions, but loads of comments and kind of connecting with you in the experiences, and lots of people resonating with them, you know, what they find. A good question actually from Colleen. So I'll read this one out. It says, don't you feel that professionals tend to make decisions based not on what the person wants, but what they feel will cause them the least trouble? Any thoughts on that motivation from professional decision making?
Them being professionals, I assume. Less trouble for the professional.
Yeah, I think so.
For me, it ranged from different things. A lot of there seemed to be a lot of distinction between I'm carrying out a job as a professional, and my job says I have to provide treatment at all costs. And if you're asking me to withdraw treatment from this person that is alive, that will be too distressing for me, and that's not a place that I'm going to. I'm not even entering into that discussion. So really kind of going against a sort of professional ethics stroke values, although that seemed to be a bit confused because you don't keep treating just because you can. That's not part of health. We all know that. I never got a sense that it was easier necessarily, but that what the opposite was being presented was way too difficult to comprehend. Just not something that can be comprehended. And for some, particularly in the June experience, when you meet people that have worked in, say, the same environment and have gone on to do other things, that you'd find out about the culture that Paul's case manager, for example, had come from a particular hospital that worked in a particular way, and that stayed with him. That was the culture of the environment that you treat.
And isn't culture interesting? You know, because you've got the culture of the family and their attitudes towards the incident, the condition, the prognosis, the death. You've got kind of the culture that's going on internally. You've got the culture of the professionals in the hospital and what's there, and then you've got the culture of your own advocacy service, haven't you, which may or may not be helping you to fight for P's voice. Your advocacy service might be kind of dampening you down, which leads us on to another question, which is, where do you get your resilience from? I meditate and do yoga twice a day to keep my brain calm.
It's difficult to say, because I mean, I guess that's part of the book, that all of that did have an impact. When you're constantly fighting with someone, that can be quite an impact. But knowing that, it's not meant to sound like a Miss World answer, but knowing that there had to be a difference. If we'd all walked away, the small sort of group of people that are involved in disorders of consciousness, the law wouldn't have got changed. The resilience had to come from P's voice deserves to be heard. It cannot keep being silenced, and that silence can't be enabled.
Beautiful. And I think, it might be worth people pausing for a second on the session and just thinking about where you get your motivation from. A lot of advocates simply just have this line in them where it's no, we're not doing that. This is not good enough. And where that comes from.
And I suppose that's, I recognise that, I see it, and I experienced it in delivering training and stuff. And I guess that's what I wanted the book to question. What does advocacy mean to you? To me, it's innate. It means someone's rights. It means their voice. We are watching politically people's voices be denied. It's innate within me. It is not just a criteria or rules. It must come from a desire for human rights, which seems a kind of basic premise of getting into advocacy. That doesn't mean that the criteria and the rules and the commissioning and the funding and all of that other kind of background noise disappears. But if it becomes the front and centre, what's the point? Because the advocacy has to come with a passion, not just a set of rules that's written in a code of practice.
And that's something that I think all good advocates have in common, is that they are not afraid to push, and they question, don't they? So when somebody says, the answer, it's always like, well, is it? You sure? Can we? Why not? It's those moments, isn't it, of either non-compliance or questioning. I think that's where we kind of grow as advocates, isn't it? It's in those little moments where you decide, no, we're not doing that. Yeah. Lovely, Grace. I think you're totally inspiring the 150 people on this call, Jakki.
Oh gosh, overwhelming. Thank you everyone that attended.
So Naya said, what can we do as advocates to support future planning or view sharing from people we work with? Also, as a person with a long-term disability that's likely to deteriorate, what can I do to make sure who I am doesn't get lost if something happens I can't express it?
I think on that part, if it's writing a value statement. I mean, for me, I had to write an advanced decision, but I had to not just say this is the treatment that I want or don't want, but to add a value statement to that, to expand on what was important. Even such things as if I'm going to die, and you can prepare for that, and it. Then I want my cats to be there. I want to be in my own environment. I may not be able to fully control all of that, but conveying the elements of what are important, what needs to be considered, who to talk to. So I think that's an element that's important. Even if you don't know exactly what treatment you would or wouldn't want, just a statement of who you are, what's important. And the part around, I think it was something along the lines of the future and a kind of culture. I mean, I think some of it is tied up with some of the conversations that stopped in advocacy stopped because of the competitive nature of contracts, and where people used to network and openly have a dialogue, that became a sort of
more difficult. Yeah.
Yes, and that again, that type of thing can't be erased, but so it can't necessarily be led by those with all of the power, but that joining up needs to come back. This type of forum, this type of conference does that, but it's one day, and it's about expanding that and seeing how somehow you can start using what you're learning from advocacy in your own organisations to bring that wider, I guess, and talk about it wider, and stops. The lens of contracts and money and criteria is a big barrier in this, and that can't be pushed away, but it has to be set aside if P is going to have their voice heard more loudly and clearly.
And the good news, don't forget, is that both the Mental Health Act that's being reviewed and the Mental Capacity Amendment Act both, provide better provisions for advanced planning, don't they, for making future decisions. Well, yeah, for planning for the future. And I guess it's just up to us as advocates to find a way to get in there. And again, I think Care Act, it's quite a broad, you can make it fit. And then, good services just have a kitty of money that they will just, and I'd never say this publicly, so I'll deny it because this clearly isn't a public forum, but they will find a way to either have that, maybe not with the commissioner, but maybe with the commissioner, but they'll do it, they'll do it. And we've got to do it. Chloe, can I invite you to ask any questions?
Not so much a question, but I was just thinking as we were going through this talk, I appeal to everybody. But why is it, like we have with organ donation, there's like it was upside and now it's up down. Why isn't there not something like that nationally for everybody where they're encouraged to write down their wishes so that if this happens to any of us where we lose capacity or lose consciousness, the advocate or whoever it is that's supporting us at the time has got a document that says this person says that in this situation he or she would want this, because surely that will make our job so much easier, because they're saying it's us that are making these decisions and not the person. But if the person had the opportunity to be helped to put this across before they lose capacity.
I agree, and I think it's compassion in dying, isn't it? Hope so.
Dying.
Yeah, because that was the template I used to do my value statement, and
I'll put the link up in the chat box.
Yeah, but you found that because you work in this field and you know the importance of doing that, as do I, and I'm sure lots of people on this call. But there are people who out there in the big wide world thinks about dying.
You're right, and
what am I going to do if I have an accident tomorrow? Do you know what I mean?
I do. I think there's different elements to it. That there are some people that know about it, and there are lots of people that work in the MCA field who don't want to do one, who say, "Yeah, I know about it," and never get round to it. So there's that. Know about it and not do anything about it. I know your point is it should be raised more wider. I think it generally tends to be used, raised when there's an obvious change in someone's cognition more than anything else. So your person with dementia, but for most of the people with dementia, even that is occurring once the person's in the nursing home. Which in 2020 is quite late on in terms of the stage of dementia. So I agree that there needs to be more wider publicity, but I think that has to come from a national level, in terms of the Department of Health, for example. The Mental Capacity Act has never been particularly publicised. Right at the beginning, the only sort of media publicity was about power of attorneys. It was always been very focused on finance.
As an advocacy group or group of people who are advocates, can we not be doing anything to encourage that to happen?
Well, yeah, is the short answer, and that's up to us, isn't it? You know, so
Yeah.
we're the army of advocates, aren't we? And I think these.
Yeah, but I'm just thinking generally within our work, you know, would there be, I don't know, like a flyer we could give out or something?
Well, it starts with our thoughts, doesn't it? It starts with our decisions about what are we going to tolerate, and also what do we want? You know, what is it that we want the future to look like as advocacy? And these sessions, you know, coming together, the advocacy awareness, and it's just up to us to keep feeding it so that we can. Loads of services are represented on like the Code of Practice writing group for the Mental Capacity Act, you know, the Mental Health Act. You know, loads of advocates feed in. There's the leadership group now that, you know, comes together. So I think, Chloe, we've just got to shout as one army of advocates, you know. And it's I take Jackie's point about, you know, it's not a fight, but it feels like it sometimes. And we can either be angels or army. I don't mind, but you know, we're here, and it's I wouldn't be waiting for anybody to do that. You know, you do it. You do it. You set it up, Chloe.
I will, but I was just putting it open to discussion. Do people agree with me? Should it be talked about more? But it looks like people do from the chat.
Definitely. And on Friday, we've got the question time. So maybe this kind of future direction, that's a good place to talk about that. I mean, we as an organisation have our black belt membership, and we're getting a really nice solid group of 10, 12 people that come every Friday to kind of reflect, sometimes emotionally dump, and other times shout, and other times we just kind of talk technical issues, and other times it's about bigger things. So I can see Patsy comes regularly, but it's things like this, isn't it? It starts with you. It's always got to start with me. It's got to start with us, hasn't it? And I think Jakki, you know, is a bloody exemplar of one person making a huge difference in people's lives.
Definitely agree. Another question. What do you do
because we've got to finish.
Sorry. What do you do as an advocate when you feel that what you found out about the person is in conflict with what the family is saying?
Great question.
Like, so if somebody's family really, really wanted to continue with treatment, but all the reports and the other ideas and conclusions you've come to are that person wouldn't want that, or it wouldn't be in that person's interest.
I mean, simply for me, it's always been about the person. It's usually quite clear when if family members or their friends are against the decision, they will, in my experience, they will usually quite clearly say, I think that a chance should be given. I think treatment should go on. I don't want their death to be like this, but I know that's not what they would want. And so, I mean, for me, because people are on different ends of the spectrum in all of the cases that I've been part of, and they moved over the years as well, and maybe were completely opposite before I met them, but then had changed. So that process has to be kind of considered, but ultimately, for me, it is simple if it's just about the person, and because I don't have. I don't owe anyone anything in that sense. As long as I can be clear why I'm advocating for something in particular, I can generally form words sufficiently to say, I know that's what's important to you, or I know this is what it feels like for you, but the evidence is. And I mean, that has to be kind of at the heart of advocacy. If you can't be confident enough, have enough courage to stand up, because that's the only job. That's the only job we have.
Well, I've just read in the chat box, everybody's gone and bought your book, and Amazon has no sold out.
Oh wow!
Brilliant.
Another really quick question.
Chloe, we've got to go.
Sorry.
Stop talking.
Lulu with the printers. So go to Lulu, by the way, instead.
Go on, Chloe.
Is your book available in audio form or not?
It's not. No, it's not. It's quite complicated to do anything more than direct print unless you have someone that knows IT. Evidently, that's not me.
Yeah.
Great. Okay, well, thank you so much, Jakki.
Thank you. Thank you,
So
everyone.
much gratitude in the chat box. I'll send you a copy because it'll be some brilliant comments as well throughout the session. So thank you so much. And our next session for everyone is about open justice. I think, do you know Jill, Jakki?
Yes,
Jill,
yes.
Yeah. So she knew you. So Jill is going to speak next about open justice and about accessing the Court of Protection, which I think is going to be a wonderful topic for advocates to listen to. But for now, thanks again, Jakki, and
Thank you.
Thank you. Bye, everyone.